Good evening, and welcome to this SEC versus Ripple edition of Legal Victory Briefs. This is attorney Jeremy Hogan, and today was the hearing with Judge Netburn as to whether the former SEC director Hinman could be deposed. And
bad boys, what you gonna do? What you gonna do when they come for you?
yes, that song means that the motion to quash the deposition was denied, so Mr. Hinman will be deposed, you bad, bad boy. And today we are going to go through the hearing, explain what happened, why it happened, and what it means for the SEC versus Ripple case, some super interesting things in this hearing, and one very, very interesting thing that you'll want to hear. It was much more interesting than I thought it would be. First off, did anyone else play the drinking game? Take a drink every time the SEC lawyer said, I sure did. And it didn't end well for me. That's a little inside joke if you're listening to the hearing today. Welcome back, and remember, as always, do not take what I say as legal advice, although it's hard to say that when I am always correct. And here I am being splendid in my prior video. But in any case, I think Ripple will probably lose on the first prong of the test, whether these are whether Mr. Hinman is a high-ranking official. And of course, I was correct. Judge Netburn ruled that Director Hinman was indeed a high-ranking official and protected from deposition absent exceptional circumstances. But let me continue. So yes, I think she will allow the deposition to move forward subject to proper objections by the SEC at deposition, but a deposition I think there will be. Sometimes it's hard to be right all the time. Thank you for watching. Good night. Just kidding. There is more to talk about because we got some interesting insight today. The legal issue at the hearing was whether the court was going to allow former SEC Director Hinman to be deposed by Ripple. The relevant law is that high-ranking officials are not allowed to be deposed unless there is some exceptional circumstance to allow it. Now, as you may know, former SEC Director Hinman made a speech back in 2018 in which he said that in his opinion, Ether was not a security. And he also, we learned, spoke with the Ethereum Foundation, I think about a week before the speech. And also he spoke with some exchanges, some crypto exchanges, about his views on whether Ether was a security. Now, why is that important? Because Ripple has pled the fair notice defense, which puts at issue whether Ripple had fair notice that its XRP token could be considered a security. The first interesting thing for me listening to the hearing was that we heard from a new SEC attorney, Ms. Stewart, I think her name was. I thought she started off really good, very strong. But more interesting was that we did not hear and have not heard from a while for Attorney Tenrero. This might be signaling that there is a change in lead counsel for the SEC. We don't know. Let's see how it plays out over the next couple of weeks. In any case, I think Ms. Stewart laid out the SEC position very strong. You can't have high-level SEC officials deposed for every case the SEC is involved in. Otherwise, the officials would spend their retirement years being deposed day after day. And you know, being deposed is kind of like having a proctology exam done for hours and hours, over and over. Seriously, this is how literally my clients are after only 4 hours of deposition.
Was that a yes or a no?
It was a fuck you!
That guy rocks in any case. So Ms. Stewart was very good until the judge asked her very first question. And I'll tell you what, it was a curveball question. It came out of nowhere. And it was actually what this hearing was all about. And the question was this. Mr. Hinman said in his affidavit to the motion that the speech was only his personal views. There it is in paragraph 13 of Hinman's affidavit, quote, "The speech was intended to express my own personal views." So the judge's question was, how can a high-level official protection privilege apply to words that he said in his personal opinion only? And that question made me sit up and take notice. I didn't expect it at all, and apparently neither did the SEC attorney, but let me get back to why that was the moment of the hearing, because I have to explain something briefly and we'll come back to that. Now, this issue was fully briefed in writing, and when I saw that the judge wanted oral argument, I thought maybe she wanted to hear more from Ripple about what they hoped to find out from Hinman that wasn't in his speech already. I thought she needed more from Ripple, but that wasn't it at all. What this was all about is that Judge Netburn is very aware that her rulings set precedent and will be referred to and relied on in other cases. And she is also aware, as any good judge is that she has to make a good record of why she ruled a certain way. Not only for that reason, but in case she is appealed on a ruling. An appeal of her ruling. Now keep that in mind. Now, the SEC made a big mistake. There was case authority on the point of personal versus official views, and the SEC had failed to file it in its briefings. Now, some judges won't even let you talk about a case if it's not filed, but Judge Netburn let her argue it anyway. It was a case called the Nachios case, and I took a look at it, and it's basically a case that was a little helpful for the SEC, but a lot hurtful, because in the Nachios case, although the official eventually won on the privilege issue, the court allowed him to be deposed first, and then after the questions were asked and the objections raised, the parties went back to court to argue the privilege arguments, which is basically what Ripple wants to do in this case. So I call this a judge's hearing because I think the judge knew what she was basically going to do already, but wanted to make a record for case precedent purposes and also for appellate purposes. She wanted to lay out that the speech was extraordinary and that Hinman said it was his own personal view that Ether was not a security, and that extraordinariness, if that's a word, was why she was going to allow it, the deposition, to go forward. But there's something that jumped out at me that you might have missed, and I had to go get my notebook so I could remember. Remember, nothing gets by me except if I don't make a note of it. So when it became obvious that the judge was going to allow the deposition to move forward, she asked the parties whether it was moving forward on Monday because it had been scheduled for the 19th already, and Ripple said, yes, it's moving forward. And the attorney for the SEC said she wasn't sure that we would need time to evaluate that, is what I wrote down. Now, this was a scheduled deposition. The judge said that she was going to allow it to go forward, but the SEC will evaluate that? Very curious. Now, to me, that can only mean one thing. Now, absent an agreement between the parties, the SEC intends to appeal the ruling allowing the deposition to go forward, or at least to consider doing that, and that's almost never done. You have no idea how rare that it would be, an interlocutory appeal. First, the standard is almost impossible to meet. The order allowing the deposition would have to be clearly erroneous, and the judge who would make that decision that it's clearly erroneous is the district court judge, Judge Torres, who was working with Judge Netburn on this case and probably even knew what Judge Netburn was going to do with this issue. So what I'm saying is a little conspiracy theorist-ish, which I am not by nature, but even thinking about appealing this order suggests to me that the SEC is desperate, this smacks of desperation, for this deposition to not go forward. Why exactly they are desperate, I do not know, but there is something there that is just not normal bad, but really, really bad. But here's the caveat to that. Ripple probably doesn't know exactly what the SEC is hiding. Maybe they do, but after today, I don't think so. And the bad news is that Judge Netburn is going to be very restrictive on the scope of what Ripple can ask about. She was unusually clear at the end of the hearing, when I think she was getting a little pissed off at everyone, that what makes the case exceptional is the speech, and maybe what led up to the speech. What I'm saying is that there is something to be unearthed here, and the question is, will Ripple be able to unearth it? Now, I don't know the answer to that, but what I do know is that this fight is far from over. We'll be seeing this issue in front of Judge Netburn again, I guarantee it. Everyone now knows that there's too much writing on it. So that's it for me. Thank you for watching. Remember to pat yourself on the back today. You are doing something good. And the question is, will Ripple be unable to unearth it? No, that's not the question.